This case is a classic small claims showdown, Triple Horn versus Halcom, and it all centers around a 20-year-old Chevy Silverado. On one side, we've got Triple Horn, who says he trusted a community connection and bought the truck, only to pour thousands more into endless repairs. On the other, Halcom insists he sold the truck fairly and that Triple Horn knew exactly what he was getting. But here's the twist. The judge wastes no time pointing out one fatal mistake: buying a used vehicle without a test drive. And if that wasn't enough, later in the case, we'll uncover a shocking discovery about the truck's check engine light. Was it a simple oversight or something more? Stick around. This one gets heated fast.
This is file 2500678SC, small claims case, Triple Horn versus Halcom. We're here in small claims trying to get this done. Mr. Triple Horn, there you go. We're trying to get this done without any attorneys involved. Everybody is here as unrepresented. We're also trying to get this done here in front of me as opposed to something like asking for a jury trial. So first things first, if you're both ready, willing, and able to proceed here in small claims, first thing I'm going to do is swear you both in. Go ahead and raise your right hand. You swear or affirm any testimony that you give here today would be the truth, the whole truth, and nothing but the truth.
Yep.
Yes, sir.
All right. So, gentlemen, you both submitted a decent amount of information to me ahead of time. The first thing I do want to ask is if you have anything else you think is not sort of covered by the information that you sent in before I would start asking questions and or telling you what I think. I'll start with you, Mr. Triplehorn. Essentially, just to sort of reiterate what I think is happening from your point of view is, you bought this truck based upon, trust and a sort of a, not that you know each other, but you sort of are in the same circles there. The truck had some cosmetic issues, but as far as you were concerned, you thought it runs fine. And then essentially, as soon as you got it home, started having problems to the point where this truck, you ended up putting more money in it than you bought it for. And you think that the defendant should be on the hook for some of those monies. Does that fairly sum up what you're telling me?
Yes, sir. I laid it out pretty explicitly in the original statement that I provided. You
did. That's why I just want to ask you if there's anything right out of the gate that you're saying, oh, and I also wanted you to know this, and that's not part of what you had already informed court.
I don't believe so. I think I submitted everything that you need to make a decision.
And Mr. Halcom, same thing. I have a lot of information from you, the sort of point of view about, you disagree with the characterization of some of the things that the plaintiff described, even in just the, condition of truck. Things like the tires or the snow that day, and submitted evidence to the contrary, and that you were very adamant about, hey man, you don't have to buy this truck. You sure you don't want to drive it around? I have all that in sort of information in my head that you submitted. Anything out of the gate though, you're like, oh, here's this one thing I forgot to submit, but I really want you to know before you start, explaining to us what's going to happen here.
Yes, Your Honor, I did forget. I was trying to find my paperwork. I gave it to the lady in the court, so I don't have none of my paperwork. So I got the receipts. That's all I wanted to add. It's only shows $1,499. I don't see nothing of a receipt for an engine or anything as of that. But yes, everything.
And I'll sort of get into that.
Yes.
First things first, Mr. Triplehorn is, and I think you even understood this because it was pretty clear in your affidavit and claim that small claims is capped at 7,000. So you actually think, hey, I got over 9,600 into this truck, but you realize the most you could get is 7,000, right?
Correct.
Now here's the problem. This truck, gentlemen, is worth about $5,000. That's what it would have Kelly Blue booked out. That's probably why the defendant was trying to sell it for $5,000. So right out of the gate, Mr. Triplehorn, you would never get more money than that. All right. So I just want you to understand your $9,600 comes down to 7,000 because we're in small claims. It's come down to 5,000 before I even start talking, because you'd never make money off this case. The best you could do is get all your money back. All right, so we're on the same page with that. Essentially, what I'm going to do is explain a lot of things to you, Mr. Triplehorn, that all sound like they're not going your way. All right. First and foremost, you know, being a halfway mechanic yourself, to not take a test drive for this is the single biggest thing you did wrong. I think you sort of understand that in retrospect, looking back. But you know that you heard the engine running. Oh, it's not knocking. It's not making any weird sounds. It must run good. Without taking it for a test drive is just, you know, buying a car from a person you don't know 101, right? The other thing is, this is not you buying it from a dealer, right? If you go and buy, if what Mr. Halcomb does for a living is sell cars, then you're protected by a bunch of things like what are called lemon laws, right? If I'm a dealer and I say, oh, look at this truck here, buy this truck, and you get it off the lot and it falls apart, that dealer is in trouble, right? Third party is different, right? Third party is, look, anything that's sort of obviously wrong that they try to, you know, cover up or not tell you about, those are issues. And we do have an issue here that I'm going to get into later, Mr. Halcomb. The single biggest thing that's going against you is that check engine light. As the trier of fact, I really don't like that fact. But I'm going to get back to you, Mr. Triplehorn. Not taking it for a test drive is what's going to end up costing you a lot of money here at the end of the day. All right. And like I said, a 2005 Chevy Silverado with 200,000 miles on it, we're not talking that it was worth much more than the $5,000 you paid, even if everything was fine with it. But essentially, the problem is, I feel like you bought this truck based on how it looked and not on how it runs. The fact that it's a 20-year-old truck, 20 years plus, well, 20 years now, and you were like, oh, well, it's hard to find one that looks this sort of shiny and new. That's where you got tripped up, you know, and not taking it for a test drive. But like I was saying here, the problem is you have what Mr. Halcomb says. You have submitted quite a few receipts, but not any receipts for 2 cylinders not firing and replacing of an engine. That is a big old ticket.
That's
you
not
didn't
true.
submit any big ticket receipts.
My receipt for the motors in there, Grand Valley Auto, I got it right here. $2,120. I submitted it to you.
Let's see here.
There's the Grand Valley Auto receipt. There's the amount.
Hold on.
2005 Chevy Silverado pickup engine with the VIN number. Purchased on 12/19 for $2,120.
I don't have that one, Your Honor.
I got a $14.99, then $63, then $87, then $184, then $67 again. It's probably the same one. Then $19, then $44.
Well, here you go.
Then $187, then $154, then $192, and then a credit for $34.97, $34, $58, and then a bunch of texts going back and forth.
All right,
so
well,
you can show that, you know, but essentially here's the problem is I wouldn't hold almost any of that against Mr. Halcomb. You want to dump money into a truck that's giving you nothing but problems? That's your decision. Mr. Halcomb's not on the hook for that. What Mr. Halcomb would be on the hook for is anything that was going on with that truck that made it worth less than $5,000 that you couldn't have possibly known about and or wouldn't have been sold by you test driving it. The other thing is too, this is not 2 little old ladies. You guys know about trucks. You're probably truck people. Did you even look under the hood?
Sir, I looked at that truck pretty explicitly, on top of the fact that I have the fact that he's the father of one of my son's good friends, who I nowhere in the world would think that somebody that lived 2 miles away from me, and his son hangs out with my son at school every day, was going to lie to me about a truck.
Here's the other problem, Mr. Triplehorn, is I have to go on credibility, right? Here's the credibility issues I have with you. You're telling me that, hey man, I was worried about driving this from when I bought it to sort of get it home because these tires are so bald and the weather outside was so bad. Neither of those two things seem to be true.
Well, you can look at the weathers on that date to see the weather.
I am, sir.
And it was.
And I'm looking at the tires on the truck. The defendant submitted both of those things. That's plenty of tread on some truck tires. And I can see the ground on December 17th.
Okay, well.
So right out of the gate, we're having some issues with not even anything about the truck, just collateral issues where I can kind of tell, all right, who is, telling me.
Number one, sir, just because someone shows you a picture of some tires on the truck doesn't mean that those pictures were taken the date that the truck was pulled off the lot. The pictures that he took of that date of that truck were from
Mr. Triplehorn,
spring.
Anybody buying a truck who's going to sit here and tell me the tires were as bald as you described
I didn't say they were bald. I said they were chopped. They were mud tires. The lugs were uneven. They were chopped. And if you did anything over 30 miles an hour, you vibrated that truck so bad that you could barely drive it. I took it.
Here's where the case takes a dramatic turn. Notice how the judge immediately zeroes in on credibility. Triplehorn insists the truck was practically undrivable, yet the defense has photo evidence suggesting the weather was clear and the tires weren't nearly as bad as described. This is a critical moment because in small claims court, the judge doesn't just weigh receipts and paperwork. Credibility can make or break your entire case. If the judge senses exaggeration or shifting details, your claims start to unravel. And here's the real question for you. Do you think Triplehorn's story is slipping here, or is Halcomb just deflecting the blame? Drop your thoughts in the comments, because right now, the judge is clearly testing whose word holds more weight.
The Pro Tire the very next morning in Allegan and had $1,300 worth of tires put on that truck because you could not drive the truck. It was undrivable over 40 miles an hour.
You would have realized that the first time you tried to drive it and said, I'm not buying this piece of crap truck.
No, I did realize it was that, and I knew it was the tires because the lug chop on it was so uneven from being unbalanced and unaligned that I took the truck home, I parked it. The next morning, I got up and I took it directly to Pro Tire Service and got 4 new tires put on it. At that point, when I pulled out of Pro Tire and realized that even with good tires on it, I still couldn't drive over 45 miles an hour without the engine missing and loss of power, I then immediately took it back to my shop and had my mechanic do a thermal scan on the catalytic converters to see if they were plugged. At that point, once we found one of the catalytic converters was almost 300 degrees over temperature compared to the other one, I took it to the muffler shop. At the muffler shop, I called Mr. Holcomb. I told him, hey, this thing is not running right. You have the opportunity to pay me half of my money back and I'll walk away from this and I'll eat the rest of it. He told me, absolutely not. That truck runs fine. After being
but here's where we get into problems, sir. The words that you're using today matter a lot, right? So remember how you just said, hey, give me half my money back and we'll call it a day. That's not what you said. No. You said, give me $1,500 back.
Correct.
Right?
Right.
That's what the problem. I don't know either of you, right? So I'm determining credibility of how you handle yourself and what you say to me right now.
Well, that's fine. But you can see in my report that what I said was give me $1,500 back.
Yeah, I know, but what you just told me is you tried to say, give me half back. And then,
I'm generalizing, sir, off of.
But I can't generalize. We're finding very specific numbers here. right? But in general, what I mean by this, Mr. Triplehorn, the biggest thing that's killing you asking for your money back here is you didn't test drive the vehicle when you bought the vehicle. You
Well,
shouldn't
sir,
do that.
I
You
talked
know
to
that.
my lawyer, who's the county prosecutor for you guys now, and he told me that it really doesn't matter if I drove that truck or not, that if there was any kind of masking of any kind of problems that weren't brought to my attention at the beginning of the purchase of this truck, that it doesn't matter if there was an as-is.
Oh, I agree with Mr. Villar, except for one thing. The but there is that you wouldn't have been able to figure out by taking it for a test drive. And what you're telling me is, if I had tried to get to 45, this thing shakes as so bad, I know something's wrong.
I wouldn't have taken the truck back based on that anyway, sir, because I knew the tires were the reason that it was chopping originally. I wouldn't have been able to diagnose a higher, more serious problem because I couldn't drive the truck over 45 miles an hour.
Gentlemen, and like I said, Mr. Triplehorn, I knew that for quite a ways here, I'd be giving you the business. But here's the but. At the end of the day, I am going to award you some money because, Mr. Holcomb, the thing that concerns me here is that check engine light. And I don't even really need to get into whether or not that's something that you knew about or didn't know about, or you did or someone else did, or it came like that. But the problem is, that's such a red flag to me of, well, the first thing Mr. Triplehorn would do when he starts it up is, oh, what's the engine light? Let's do the code. And you could be like, oh, that's just a minor thing. That's fine. But you guys didn't even go down that road because the check engine light's not working.
No, right? I agree with you, Your Honor. I agree.
And that the check engine light, it was a little bit more than not working. It had been made to not work.
I just want to say one thing.
Yes.
When you turn the key on, if I, as he said, removed a light or anything, Dee said, just as you will, when you get in your car, you turn your key on, you see all the lights come on before you tend to start the vehicle. That truck showed a check engine light, oil light, seat belt, airbags, all of it, Your Honor.
No, it doesn't.
I never once.
The problem is,
but yes, I agree.
I'm not a mechanic, and
yes, sir. Neither am I.
The mechanic that Mr. Triplehorn took it to referred to this as the check engine light has been disabled.
Yes, right? You're right. I completely understand.
But essentially, what I'm still going to do here is essentially, gentlemen, you had even mentioned it at some point in time, what you thought would be fair. Yes. And what you thought would be fair is it's not a $5,000 truck. That it's worth less than that because there was issues with it. It was only ever going to be a $5,000 truck, even if it was running well. So that's why, Mr. Triplehorn, if you choose to go down the rabbit hole of throwing money into the truck, that's your choice. But what I would do is, what you guys need is a third party to just come in and go, boom, gentlemen, this is what I'm doing, and then explain to you both how you would have the option to agree or disagree with that. But what I'm going to award here is $1,500 in damages. And then, because the other thing I need to explain, Mr. Triplehorn paid certain monies out of pocket to get us here today. He had to pay a filing fee to court. He had to have you served. That was $107.50. He is also entitled to that. We call that costs as opposed to damages. It's a different thing, but I just want you to understand, Mr. Holcomb, when you see this judgment for $1,607.50, where that extra money comes from.
Okay.
Now, gentlemen, here's the important part. Your rights on appeal. All right, Mr. Holcomb, because you think, I don't think I owe him anything, and Mr. Triplehorn, because you think that number is too low. Either of you can appeal my finding and say, I want to take this to general civil in front of the district court judges. To do that, you must do two things. One is you must ask for that within 7 days of today's date. The window of opportunity closes after 7 days to contest my finding. And two, you must ask for that in writing. It's not good enough to just call the clerks up and say, hey, I want to appeal that finding. So do you both understand your rights on appeal, Mr. Triplehorn?
Yep.
And Mr. Holcomb?
Yes, sir. I agree.
All right. So, gentlemen, the court does not do collections. You will both get a copy of this judgment. If neither of you are choosing to appeal, then we do expect the parties to be able to satisfy the judgment. In other words, work out between you how and when you're going to get paid. And if either one of you appeals, this process will start over again in front of the district court judges. But with that, I can go ahead and release parties. Thank you.
Perfect. Thank you, sir. Have a good day.
So here's how it all ended. The judge sided partially with Triplehorn, awarding him $1,500 in damages plus court costs, far less than the nearly $10,000 he claimed. Why? Because the judge ruled that buying the truck without a test drive was a massive error, and most of the repairs were Triplehorn's decision, not Halcom's responsibility. Still, the disabled check engine light raised enough red flags to make Halcom accountable for at least part of the loss. This case is a perfect reminder of how risky private vehicle sales can be. Trust isn't a legal guarantee. What do you think? Was the ruling fair, or should Triplehorn have gotten more back? Let us know in the comments. And if you enjoy these breakdowns of real courtroom drama, don't forget to like this video, share it with a friend, and subscribe for more cases that will leave you stunned.